Today's session is mitigating risks and protecting profit during the construction phase. And for you all as design firms providing services, the construction phase is a challenging phase because the design solution that you presented to this client is now being put to the test. During this session, we will discuss how you need to think about some of the services that you're providing, how to mitigate those risks, and at the same time, while providing services to your client, how do you make sure that you're doing so in a manner that makes sense for your firm and you're still maintaining a profitable practice during this important phase for the client? So we will talk about your roles and responsibilities during the construction phase. We'll talk about the scope of services that you as a design professional will be performing for the client. And then we'll delve into reviewing submittals, observations, evaluations, substitution requests. These are all the communication issues that you have to administer on behalf of your client. Then we'll talk about how to go about preparation of contract changes and what some of the risks are. And then finally, project completion issues that need to be addressed. But before we go into all of that, we first need to understand what your roles and responsibilities are during the construction phase. Now, for this presentation, we are assuming that you are in a design, bid, build environment, and that during the construction phase, there are actually two separate contracts that govern the relationships between the owner, the design team, and the contractor. You, as a design professional, have a separate contract in a design bid build environment that allows you to provide services. The owner, of course, has the program and the site, and you as a design professional have provided to the owner contract documents that they will use with the contractor. This means that as a design firm, you've already done the design of the permanent work, and now during the construction phase, you will be engaging in providing services to the owner to administer that construction contract that the owner is going to enter into with the constructor to get the project built. One thing that you need to understand in a design bid build environment is that your services and your providing services are governed by your contract. And one of the ways to maintain your profit during this phase is to make sure that your scope clearly identifies what it is that you're providing for the owner. A couple of things that we need to discuss as it relates to the relationship between the owner and the contractor. When the owner provides these construction contract documents that you've prepared to the contractor, they're providing it to the contractor with an implied warranty. This is called the Spearman Doctrine, and it comes from a 1918 United States Supreme Court decision. And in it, when the owner provides these documents to the contractor, they're providing that there's an implied warranty that the information presented to the contractor is sufficient for the contractor to construct the facility. And if there's material or information that is missing, then indeed that is the owner's responsibility. So if there are additional costs, the owner is going to be responsible for that. Because of that warranty, of the implied warranty, the owner therefore has ongoing responsibilities during the construction phase to try to provide information to the contractor to get this project going. Even though if you have a bid, the owner still has a vested interest in making sure that the contractor has enough information, because otherwise, if there isn't information that the contractor needs, that additional cost is going to fall on the owner. And you as a design firm are essentially assisting the owner administer that contract. You are there to administer the contract for construction. You're not doing construction administration. You're not there to help the contractor manage their firm their staff or manage the process. Your role is that of an agent for the owner. So it's important that you realize exactly what your role is. And one thing that we see firms get into trouble for is that when they take on responsibility for the actual construction, when they are actually supposed to be providing services to the owner. So you need to know exactly what is in the construction contract documents. It is amazing to me how often folks try to help the owner out, but don't really have the contract that the owner has executed with the contractor to begin with. If you don't have those documents in place, then it's very difficult to administer the contract. So you should know what are the owner's rights and obligations as spelled out in the contract between the owner and the contractor. What are the contractor's rights and obligations in the documents? These are all things that any design firm that is providing construction contract administration services should be able to spell out and identify what that contract says. It's you as the administrator need to be able to provide answers when the questions come up. Now, the contractor clearly has business risks associated with undertaking a construction job. They are responsible for the site, means and methods, safety. They develop a schedule of values, and to that end, they need to be aware of what those risks are, and they need to know what the site looks like. They have a responsibility to visit the site, check the plans, and inform themselves of the requirements of the work. If there are issues that they identify related to your design solution, the contractor has an obligation to note that and notify you and the owner about the discrepancies that they see. So the contractor has affirmative responsibilities as it relates to the undertaking that they have taken on. But along with that comes a lot of business risks that they take on. So you have the owner responsibilities, which is to pay the contractor, administer the contract, and then you have the contractor's responsibilities to get the finished facility in place. So what does the scope of the construction phase services look like? What do you as a design firm offer to the client? Well, the first thing that you need to think about is, well, does the owner want me, the design firm, to provide services? Often what we see are owners increasingly saying, well, we have got the design document, we've got the construction documents, we've been able to pull the permit from the authority having jurisdiction, and from this point on, we, the owner, or some other entity that they hire, will take the responsibility for that. And if that's the case, the owner is certainly within their rights to do that, but you need to think about educating the owner about what that entails. So anytime you are providing construction phase services, you need to clearly detail the scope of services you're providing during and after the construction phase. So do they want to administer the construction contract on their own or engage somebody else? If that's the case, what limited role do they want you to play, or do they want you to completely step out of involvement during the construction phase? That has to be spelled out. I think that is one of the reasons why a lot of firms lose money during this phase, because they don't have a detailed scope, and they're still called on by the owner to respond to questions, to respond to issues, even though you don't have that phase, that responsibility during that phase. So it's important that even if if the owner wants to say, we don't want you involved, you need to say to the owner, okay, do you want me involved in any shape, form, or manner? What are the issues that the owner needs to think about as they are going to pursue a certificate of occupancy from the authority having jurisdiction. Does that mean that at some point a design professional such as yourself will have to be involved to provide the required certification to that authority? How does the owner intend to get that in place if you're not to have a role? If they are engaging somebody else or they want to do the work themselves, what do they expect you to do? Do they expect you to respond to the RFI, the shop drawings, or some other combination of services? That needs to be detailed out and clearly identified in the scope of services that you're providing to the client. You need to detail your assumptions about the level of effort required. Construction phase activities can take any number of turns depending on what happens during construction. Construction is inherently uncertain depending on the site. It could take longer than anticipated. What is it that you are assuming, and are those assumptions clearly stated in the scope of services that you're providing to the owner? If, for example, you're saying, well, we think construction is going to last 9 months, then that assumption should be clearly stated in the scope of services so that in the event construction takes longer, you have a mechanism to go back to the owner and renegotiate what the scope of engagement looks like because it's going over that stated time. It doesn't mean that because it went over 9 months that it's your responsibility, but if there are things that happen on site and it takes longer and your involvement on site or during the construction phase is longer, then that needs to be recognized, and that should be an additional service or an opportunity to revise what it is that you're providing so that you can make sure that this phase still remains profitable for you. So I think one of the things that design firms should certainly advise the owner on and be advised that, how long do you anticipate the construction phase services to last? If the owner does not want construction phase services, you need to protect yourself. You need to think about, okay, that is certainly their right. The owner can proceed as they wish, but number one, you need to educate the owner about what is going to be needed in that particular jurisdiction. To the extent possible, you can educate them, notify them what the things that you're aware of. But if they don't want your services, you need to protect yourself. You can say clearly that you have no obligations during the construction phase. You want a clear statement that the owner assumes all responsibility for the application and interpretation of the construction documents. This is something that the owner is going to have to resolve on their own. Ideally, you want the owner to also recognize that during the construction phase services, because you are not involved, you want a waiver a waiver of claims for issues that are connected to the construction phase services. Such a waiver from the owner to you would argue is reasonable because you have had no involvement during the construction phase. They've decided not to engage your services. And as such, it's a reasonable exchange for that phase so that you have some certainty that you're not going to be involved during that construction phase, and if issues should arise, it's clear that the risk falls solely on the owner. That's the type of attitude I think would make sense from a risk management standpoint if the owner clearly says, we don't want you during the construction phase. To that end, I have included here some sample language that you can adapt for your needs. This is pretty comprehensive. I think it addresses all of the things that are typically asked of a design professional. If you have this type of language and and you don't have construction phase responsibilities, in the event that the owner should come back and say there's something that we need from you or there's an issue during the construction phase, then this gives you a pretty strong position to argue that, hey, it's clear that the owner and we agreed on what my responsibilities are, and furthermore, here's the language that we agreed on. So that at least curtails the responsibility that may come up, maybe alleged during the construction phase. You're still going to be held responsible for the design solution that you presented, but any issues related to the construction phase and the applicability of that solution to the construction site, you have a pretty strong defense if you have this type of language in your contract. Obviously, any sample language that we provide, we urge you to seek the advice of local counsel, but this certainly should get you started along the right track. So the next major issue that we see are submittals. Submittals take up a lot of time to review and present a challenge for design firms, making sure that you're still profitable during this phase. And really, these are shop drawings that are being used as communication tools. And one thing that firms often forget is that shop drawings are just that. They're communication tools. An article I read recently stated that you should think of shop drawings as the last mile of a project's design. What you've been paid for through the construction document phase is to get the design kind of to the zip code, to the area of where it needs to be. But the construction documents will get it right to the address. The last mile, so to speak, requires the contractor to communicate with you by submitting shop drawings for you to approve or confirm and sometimes finalize the details of the design. Of course, you can't just rely on the contractor to provide you with solutions in your construction documents, because oftentimes the authority having jurisdiction that is reviewing the drawings wants to know what the design solution is going to be. So you can't simply rely on shop drawings to finish the bulk of the work and hope to be able to have the contractor develop the solutions completely. That's not practical, nor would that get the owner what they want. But the shop drawings are indeed a very valuable and necessary piece to get this solution resolved. The client oftentimes doesn't pay you enough for you to actually detail out the final design solution because there's not, there's a limited fee. And that is the way the industry has developed. People don't look to the design professional to detail the last detail of the design solutions. So shop drawings are necessary and needed in the construction industry, and that is one reason why it's very difficult to provide solutions because each design is particular to the site. So the thing to realize from a management standpoint is that you need to understand, okay, here are the submittals that we require, but for this to make sense, because you're providing services, is you need to be able to say, what does the schedule look like and how does that work in with my planned work so that I know when to expect these submittals. For you to protect your profit, you need to be able to say, okay, this is the level of effort that is required, and this is when I expect these submittals to come, so that you can properly plan, to the extent possible, your resources and make sure that this is indeed a profitable offering that you provide to the owner, and it makes sense for all involved. So insisting on a schedule of submittals from the contractor is often required. It's often required in their documents, but you need to insist that they give you with a schedule so that you can plan accordingly. And you need time for review, not just the initial submittal, but oftentimes there's a resubmittal process, and you need adequate time for that, and make sure that you are charging for that, whether it be lump sum based on your assumptions or on a time basis. But however the case it is, that needs to be properly planned for, and of course, it also needs to be coordinated with the construction schedule so that all parties know what is expected, and the time for review is baked into what the expected length of the construction time is. So the other thing to do is to make sure that the contractor knows what their responsibilities are. Obviously, shop drawings should always come from the contractor, and they should affirmatively check what the subs and their suppliers are proposing, review it, and then pass it on to you. As such, you should always insist that the contractor indicate that they reviewed what the underlying submittal is before giving them to you for your review. That it makes sense, that is protective of your interests, and make sure that you're not essentially coordinating the contractor's various suppliers and subs on their behalf. That is the job of the contractor, and that makes sure that you are able to plan your work, and that you're not taking on additional services that you haven't planned for, and thereby lose money during this phase. Only review the shop drawings that have been required of the contractor. Again, your job is not to make the contractor's job easier by doing their work for them. If a shop drawing is not required, if a particular submittal is not required of you in the construction documents, but the contractor sends it to you, make sure you respond back and saying this is not required, it's not on the schedule, we don't need to review this, it hasn't been asked for us, and that has a twofold purpose. Number one, you're not spending your time on something that you haven't been paid for, and number two, by not reviewing it, you're not assuming responsibility for something that hasn't been asked of the contractor, and so you're not taking on responsibility for that. Especially in particular areas such as site safety and other issues, you want to be very wary of stepping into that role. If it's not part of your scope, that should not be part of your services. And if any time that the contractor wants you to bless something that hasn't been asked of them in the documents, you can just return it back and say, this has not been reviewed, it's not part of the submittal requirements, and that is one way for you to maintain profitability during the construction phase. So let's look here at the sample language that the AIA provides. And throughout this presentation, I'm throwing out some language here from both the EJCDC and the AIA so that you get a flavor for what the description of the way the standard form documents think of these responsibilities. And this is from the AIA A201. This is the general conditions that the contractor has. And as you can see, they are representing to you and the owner that they have reviewed and approved the shop drawings, determined and verified materials, field measurements, and field construction criteria, and checked and coordinated the information contained within such submittals with the requirements of the work and the contract documents. All of that is still the contractor's responsibility. It's not the design firm's responsibility to do that. Your job is to check that what they are submitting is indeed compatible with the design concept as expressed in the construction contract documents. If it works, if it makes sense and they have done the contractor's done their job, then you compare that, make sure that it works with the concept as expressed. If there are any deviances, you note that and inform the contractor. You're only reviewing and approving the aspects for which the design professional is responsible. And then once it meets your criteria, you place a review stamp, and we'll talk about what these review stamps say, and return it to the contractor based on your determination. If, especially at the beginning of the job, you insist on the contractor following the protocols that are required of them, this generally helps everybody get on the same page. So especially at the beginning of the job, you want to let the contractor know, hey, these are your responsibilities. It doesn't look like you have coordinated this with your other subs or with the design concepts. Please review and resubmit. And especially at the job, at the beginning of the job, if those expectations are set correctly, then as the project progresses, you have a chance of actually having a process that is fairly efficient and works well. If you don't take the opportunity to establish that at the beginning, then it becomes more problematic as the job goes on, because the contractor has gotten away with not adhering to what is expected of them. The other thing that I want to briefly touch on is delegated design. In some cases, you may give the contractor design responsibility for a specialty scope of the work. It's often another design professional who's engaged by a supplier or a fabricator. You must, for this to work, of course, you have to specify all of the performance or design criteria that must be satisfied. And you're still required to review and approve the contractor's submittal for conformance with the design concept. Delegated design is often used for things like shoring and other items during the construction phase that require somebody to take it to the next step and have a design professional review. You will still need to provide sufficient information in your drawings to be able to pull the permit from the authority having jurisdiction. So again, you can't just say, oh, we're just delegating the whole design to the contractor. That wouldn't work in the design bid build environment. But the delegated design issue is indeed part of the toolbox that you have. And again, you need to look for exactly how this solution works with your concept, and you're still obligated to review that solution. Even if there's a licensed professional who stamped and sealed it as the person providing these services, you still have responsibility for that. So act accordingly. And then the last thing one of the things I want to point out is, this issue of what should my submittal stamp say. Generally, we at Schinnerer, when we provide guidance, we don't distinguish between whether you should use the term no exceptions taken or approved. As long as it's clear in the stamp what it is that you're reviewing it for, and that is clearly expressed, you still have responsibility for reviewing it and making sure that it works as part of the solution that you provided. So the key is to make sure that the language that you use in the stamp reflects your obligation and your construction phase responsibilities, that it's only for general conformance with the design concept and for information given in the construction documents, that the contractor still has a responsibility to review and coordinate and make sure that this works for their construction means and methods. So for this to be a profitable endeavor for you, you need to think of, okay, what is the summary list of submittals? Are these coordinated? And is each party fulfilling their contractual obligations? And do we have a log that is fairly standard now that reflects both the as planned and actual receipt and return dates and actions taken? This allows you to review how long it's taking you to review the submittals and make sure that indeed the time that you're allocating to these activities are that it's reasonable and that you are learning from the submittal process, so that for the next job, even if it's taking longer than expected, and if you're in a lump sum environment, you should be able to refine and improve your processes so that if you are in a lump sum environment, you can say, okay, well, I thought it would take me this long, it took me longer. We need to rework how long how we're gonna price this part of the project. These are the issues that need to be considered if you want to be able to maintain profit during the construction phase. So the next area that we want to touch on is observations and evaluations. This is another phase that could be problematic from a maintaining profit standpoint if your assumptions don't bear out correctly. So oftentimes during the construction phase, you're asked to do site visits during construction, or you have resident project representation. These are oftentimes stated, if you have resident project representation, obviously you have somebody there on site every day, or you say we will be there during construction phase, once a week, or however the case may be. The activity involves communicating and documenting what you've seen. If there are things that you take exception to that you don't think make sense, you need to document that, communicate both with the contractor and the owner. Who's responsible for programmed inspections and testing and specialty inspections and testing? Who's there on site to make that happen? You may well have a role in that. We will talk about certifications when we talk about pay applications, but oftentimes you're asked to certify that something happened or was conducted as accordingly. But the next thing that I really want to talk about is your authority about non-conforming work. If you have the authority to reject non-conforming work, you need to plan your activities around that very carefully. Determining that something does not conform and therefore should be rejected is obviously a very important task that you're providing for the owner. And a lot of times the owner says, you have the opportunity to advise us, but it's not your job to reject it. The owner oftentimes likes to keep that authority to themselves. But if you do have that authority, you need to understand that requires care on your part. Because any time that you reject something on your own authority, that is going to imply that the work is not sufficient. And it's not just implying, but you're actually saying that. And furthermore, there's going to be additional efforts by the contractor to make it conform. So the reaction from the contractor may well be that actually your decision was not correct. So it could often lead to acrimony and disputes. And so you need to be prepared for that. That oftentimes eats up time, and that impacts the profit that you may be anticipating. So I think if you have this kind of authority, it makes sense from a business standpoint to look to make sure that this type of activity, if it is engaged, is is still profitable. If in the past this type of activity has taken a lot of time, you need to rethink, well, should we continue to provide that service, and how do we as a business make sure that if we're in that event, we are not losing money, and that's a business determination on your part. I think it's a valuable service that the client gets from you, but it's also a business consideration as to how much time these types of activities may take, and that's something that you need to address internally. Obviously, the owner does have the right to accept non-conforming work if that is their decision, but you need to make sure that that is indeed their decision and that they are advised as to what they're accepting, as long as it doesn't violate some known code or limitation. Then the owner can accept non-conforming work if that is what they want to do. If you are rejecting the non-conforming work, you don't want to be stepping into the role of a contractor. The corrective solution should come from the contractor. They should decide on the means and methods. You are obviously focusing on the results, whether the solution does conform with the design solution. That's how this activity should occur, so that you are keeping profitable with this phase. The last thing that I want to touch on are payment recommendations. Oftentimes, you as a design professional are responsible for approving and reviewing payouts, and this goes along with your site observations. Once a month, you may have a payout. You need to decide percent complete. That's indeed a fairly valuable service to the owner, because they want somebody to tell them, yes, indeed, this portion is this percent complete, that portion is a different percent complete depending on the schedule of values, and that determines how much money should be paid. Contractors obviously want to get paid as quickly as possible, but you don't want to be in a position of the owner having paid most of the money without the work in place reflecting that. That could imply a lot of different things, and that's a problem. So if you have this responsibility, you want to make sure that you're taking enough time to provide the service, that you are indeed aware of what's going on site, and can make a determination independently of what the percent completes are, because you're expected to perform as an independent, verifying what the percent completes are. So you're making a recommendation or a certification to the owner. And the other thing that you need to realize is that this does not mean that the contractor has paid their subs. If there are issues or concerns about that, there may be a payment bond that the contractor is certified that they will pay their subs. But generally, as a design professional, as a design firm, it's not on you to confirm that they have made payment to their subs and suppliers, and you don't want to get sucked into those types of issues. Generally, it's up to the contractor to certify that they have indeed paid their suppliers and that they are releasing liens as they get paid throughout the project. The other thing that I've seen that causes problems for firms are substitution requests. And this is an area that, again, can eat up a lot of time and needs to be planned accordingly. But oftentimes, the contractor will propose a substitution, and it will be on you as a design professional to review the substitution request and make a recommendation whether to accept it or not. And oftentimes, it's your responsibility to make that decision. If there is indeed a proposed substitution, you should require the contractor to certify that indeed it will adequately perform and achieve the results called for by the design, and this is a certification that you need from the contractor. This is what the standard form documents anticipate from the contractor, and that it be similar in substance and function and act the same as the original item. Require the contractor to state the impact on the schedule and cost so that it is clear what they're saying, what the proposed substitution will do, and what the benefits are, and what the impact will be. And then require the contractor to identify whether the proposed substitution will require a change in the construction documents. And this is oftentimes the challenge for firms who are reviewing substitutions, in that the substitution may well be acceptable or beneficial, but there are other changes that need to be made to accommodate that, and that requires services on your part. And so how do you get paid for that? Is that adequately planned for? Are you making sure that oftentimes this is an additional service, but it is on you, the design firm, to know what your services say. The standard form documents anticipate that this is an additional service that the owner will pay for, but you have to follow up with the owner and say, hey, this is an additional service that you need to get paid for. If you don't identify and act accordingly, then oftentimes this could be a loss leader for your services. Of course, when you do get a substitution, you want to obtain feedback and comments from the owner in regards to the substitution. Ultimately, they have to be kept aware of what's going on. If you need it from the contractor, you want to seek additional data about the proposed substitute item. But ultimately, you as a design firm, when you're reviewing these, you have to establish that you are the sole authority on this matter. It is ultimately you who are responsible for this phase. If you are reviewing substitution requests, your word matters. And so if you think it makes sense and is beneficial to the owner, you'll approve it. If it doesn't, you will reject it. And the contractor needs to understand that no substitution will occur until your review is complete and you determine it is an acceptable substitute. What takes up time oftentimes is the contractor going ahead with a substitution solution without the proper consultation, without the proper authorization. That is an administrative nightmare, and you don't want to be in a position of having to rework stuff just because a contractor went ahead without your approval. So it is important that you establish your authority when it comes to substitution requests and reviewing these requests. Now, if you do not approve the proposed substitution, you need to advise the contractor in writing. Obviously, the owner has been kept informed, ideally, but that needs to be formalized and said, hey, you did not approve it, so that it is clear that it was rejected. Now, if you do approve a substitution request, you need to show how that is going to be effective, because remember, the request is just that. It's a request. It's a communication. If you approve it, that needs to be reflected in the documents, in the construction contract documents. You can issue a field order or a proposed change order, and we'll talk about what a field order is momentarily, but the change order should show the substitution itself and all related impacts, the change in the contract price, and or contract time. And you need to be able to track your time reviewing substitution requests. And typically, as I said earlier, this is an additional service to the owner that you can charge for, at least if you're using the standard form documents such as the AIA or the EJCBC. So the next to last thing that we want to talk about are preparation of contract changes. And as I said at the beginning, you are administering a construction contract, and administering means basically a lot of preparation of documents, and anything that has been communicated to you if it means that there's a change in the design solution, that needs to be reflected as a contract change. And in the construction industry, there's several methods of doing this. It can be a minor change field order if both you and the contractor agree that it is a change, but it is minor in nature and doesn't have any effect on the pricing or the time. Then it's a change field order. This is often done by consensus. You issue it. It is reflected in the construction documents, and the contractor proceeds. If, however, it is more substantial than that, oftentimes then a change order has to be negotiated. It can be an addition, a deletion, or substitution. All of these things have to be agreed to, and if it's a change order, it's something that the owner and the contractor agree to. The additional work is scoped out, the additional time is agreed to, and so on. So that is a change order is something that both parties agree to. If the owner and the contractor can't agree to what the change order should be, but the owner feels like this needs to happen and you don't have the time to negotiate a price or settle on a change order, then the owner can issue a construction or a work change directive. And this is an order from the owner to the contractor saying, hey, go ahead and do this. This needs to happen now. We will work out the additional time and money later on. And that's an order. So those are the methods in which you can effectuate a contract change during the construction. So how does the field order look like? In the AIA documents, you may order minor changes in the work that are consistent with the intent of the contract documents and do not involve an adjustment in the contract time or an extension of the contract, adjustment in the contract sum or an extension of the contract time. Or you will prepare change orders and construction change directives for the owner's approval and execution in accordance with the contract documents. In the EJCDC form, this is your scope of services. You will recommend change orders and work change directives to the owner as appropriate and prepare change orders and work change directives as required. Remember, because the contract is between the owner and the contractor, you're preparing these change orders and work change directives for the owner so that the owner can go ahead and do that. If it's a change order, obviously that will need to be executed by both the owner and the contractor for it to take effect. These are services that you are providing to the owner. And as such, you need to be compensated for that. But this is oftentimes an area that is left without being properly compensated for, because you're trying to provide a solution and get things going, but this is an area I think that oftentimes is left neglected. So this is a more detailed explanation of what these things look like, and we've discussed this already. So the last thing that I want to talk about is the final days of a project. And this really has a huge impact on your overall profitability and success. What the owner most remembers about a project is not how they start, but actually how they finish. And if something goes wrong at the end, what could have been a perfect project could turn out to be an absolute nightmare. You may think things are going well, but then when it comes time to actually complete, you may run into all types of problems. You could have the subs disappearing, change orders that you thought had been negotiated turning into actual claims. and then if the client starts, if the contractor starts demobilizing, then your client, the owner, is going to start essentially freaking out that the contractor's leaving the site and it doesn't look like things have been done. So this is a very important piece for you to help the owner plan accordingly. So, we have some general guidance, but, a closeout conference to get everybody on the same page as to how the handover of this construction site is going to be done is essential. For larger projects, this could actually start as quickly as, soon after the start of the project, so that you have regularly scheduled procedures and undertakings about how this is going to look. As a design firm, you want to make sure that all the principal stakeholders, the owner, the contractor, are involved in the closeout procedures, and that they involve their key subs in this procedure so that it is clear how this handover is going to happen. As the firm providing services, you need to know what the contract requirements are and how responsibility for each element is going to be allocated. Your goal essentially is to document and confirm that all of the work in the contract has been completed or will be completed by the time the final payment is going to be processed. To that end, you will work to develop with the contractor and the owner, how are we going to get to this substantially complete phase that we need to identify, so that you can say, hey, at this point, the project has progressed to the point where it is sufficiently complete so that the owner can start utilizing the project for the purpose for which it is intended. That is what substantially complete means, and it means something in the industry. It's oftentimes defined in your contract. So the goal is to, okay, at what point are we at substantial completion? This has a lot of implications for both the owner and the contractor. So you want to establish due dates, identify the minimum criteria for substantial completion, and then address the closeout checklist at each progress meeting. And the key is for you to emphasize what the turnover is going to look like from the contractor to the owner, to the client. That needs to be coordinated so that everybody's on the same page. And to that end, you need to think about, okay, what are some of those things? Do we need operation and maintenance manuals that are part of the contract? Has that been prepared and turned over? What's the owner training on the operation of the facility look like? What are the warranties that have come with the equipment that has been installed? Has that been transferred to the owner? And what does it look like as far as punch lists and final completion and inspections? All of these things need to be addressed as part of the closeout. And this is a lot of times, again, key to making sure that the owner is comfortable with what's going on and that the contractor is still on site and performing the job. Now, it's often said that you need to make sure that the contractor is engaged throughout the project, especially towards the end. And oftentimes, firms will tell you that the quality of the work that's installed towards the end is not the same as at the beginning, because oftentimes the contractor is trying to move on. So you as a firm need to be aware of that and make sure that there are enough resources that are being allocated by the contractor to finish the job completely. And then finally, what does a final inspection and payment look like? And finally, as a firm, there's a final pay application. This is it. So if you're processing a final pay application, this means that all punch list items have been completed, all outstanding issues have been resolved, there are no outstanding change directives and no outstanding change orders. Because if there are any outstanding change orders that haven't been resolved, that is a claim. There's nothing else to it but for the contractor to file a claim. So you need to be aware of where the statuses of all of the outstanding issues are. And once you pay up, once the owner pays, that should be it. Everybody goes home. Hopefully the project went well, and you have indeed provided these important services while still maintaining profitability for your firm. So that essentially are some of the key items that I think are important for firms to address, making sure that you're providing a valuable service that is beneficial to the owner, while at the same time making sure that you're maintaining profit and scoping the services that you're providing correctly. So that essentially brings us to the end of the presentation. Hopefully this is useful to you. I'll be happy to look at the questions that may have come in, and I'll address it. We simply don't have enough time. But I do want to thank you for your attention and bring to your attention the Schinnerer School of Risk Management. We urge you to visit our website. This is what it looks like. If you've not already established an account, you should do so. Once you register, you can view our claim studies, practice management information, contract language and commentary, past webinars, and much more. So this is the solution that we provided for our policyholders, and take a look at that. And if there's any questions, please let us know.